Mr. Dwivedi, look at the way this whole process has been done. Originally, NISA, NYSA, I presume it is NISA, appointed without a tender.
No, I'm not defending that.
Then that data fintech comes in place of NISA. The chairperson of the staff selection committee says, I don't know how they have come in. The OMR sheets are completely destroyed by the staff selection.
No, that's a second issue.
The mirror images are not there on the server anymore.
Yes.
People who are not on the panel are recruited. I mean, this is completely, it's a fraud.
I represent those who are in the panel.
No, just a minute.
We were in the panel, we were appointed, we are substantive. And how did the High Court terminate? High Court is not the appointing authority to terminate people.
But my issue, let me complete my issue.
Yes.
This is a different issue.
Yes.
I'm not on the issue of how these people were appointed and whether CBI found 8,000 odd candidates whose name have been found. So that's one part of it, that on the base, because CBI finds 8,000, how do you set aside 23,000?
No.
All of them.
So the whole process was replete.
No, but that's the second issue. I'm on the first issue. I'm more on the first issue, on behalf of the state. And that is, if your Lordship looks at page 281, this has nothing to do with that appointment.
Just 1 second.
At page 281, this is post-appointment based on that selection list. There were certain wait lists. To accommodate the wait list, page 281, number 8 at the bottom. The High Court has directed that CBI will undertake further investigation with regard to the persons involved in the state government approving creation of supernumerary post. To accommodate illegal appointments if necessary, CBI will undertake custodial interrogation if necessary. Now, this is a case of creation of supernumerary post for waitlisted candidates, which was never implemented, and only one person was appointed whose appointment is upheld by the High Court.
So why was supernumerary post created? Once they found that these appointments were illegal, High Court decides.
No.
The government decides to create.
By that time, there was no order of illegality. When this order was passed, there was no finding of the High Court about illegality. More than this, the state government passed the order in May, and up till November, no person was appointed. Then somebody challenged a writ petition, a separate writ petition, where that order was stayed. And that is a separate petition which is still pending before the High Court. And in this matter, an unimplemented order, it's a question of criminality. Illegality is one part.
But ultimately, this is only a direction to the CBI to undertake the investigation.
Custodial they will register an FIR. The whole cabinet is involved. The whole cabinet during election goes into the jail. There's another incident.
May I just add to what my learned friend is saying? These supernumerary posts, the object was that since there are these challenges pending to illegal appointments, let people at least in the waiting list, that was the thought, maybe right or wrong, supernumerary posts be occupied by them so that there is no vacuum. A detailed cabinet note is prepared on the matter and placed before the cabinet. Now, ultimately, my lord, what is the import of this is that anyone involved in the preparation of the cabinet note, right till the approval of the note by the cabinet, can be interrogated by the CBI because and why were supernumerary posts created and taken into custodial interrogation. The important thing is this was never the subject matter of the writ that your lodges are dealing with. The impugned order arises out of a writ petition which has nothing to do with supernumerary posts or a cabinet note. That's a separate writ petition in the Calcutta High Court pending before a single judge where that cabinet note has been stayed. That's a subject matter of a separate petition. Now, Sunday in a division bench dealing with the issue of the larger issue of criminality picks up the cabinet note and says that the CBI can look into anyone who prepared the note or how these supernumerary posts were created. Now, to look at how supernumerary posts were created, you will look at the cabinet note, then you look at the officers and the cabinet.
We got the point. We hear the other side.
This petition, there is no pleading at all about it.
No, but this is the wrong SLP. This petition was not heard.
Send us back to the High Court. The High Court says I will not give. Saying that your appointments are cancelled. We see that, my lord. High Court expressly said I won't hear you. And return to page 147.
147.
Para 147.
When do we get that?
Yes, para 147, 124, sorry, 124
what?
at page 157.
Internal page?
Not internal page, just see para 124, ma'am, of the impugned judgment. We were before your lordships in the first round. Take it from my lord.
65.
165.
Yes.
Now see, Lord, one PDF page. PDF page 205. Para 124. In our understanding, all writ petitions relating to recruitment process initiated in 2016. Now, Lord, recruitment process started in 2016, completed in 2018, appointments issued. First writ comes in 2021. Justice Gangopadhyay takes it up and issues notice. That's the foundation of this appeal now. Was directed to be heard by division bench, but only those petitions relating to categories as noted above in respect of so-and-so and instituted so-and-so, and appeals arising out of orders passed in such petition. We have understood para 1 of the order of November 9, 2023, that's your lordship's order, to prescribe categories of matters as also time limit filing writ petition. We have understood order of assignment of the Chief Justice in this context. Now see your lordship's order. Para 10 and 11 of your lordship's order. Lord, 9th PDF page, 9th November 2023. Just see that.
Para 9th November order.
Lord, kindly turn to my lord. Direction. The lordships have got direction.
Where is that?
Lord, a PDF page. 157 PDF page. Your lordship's judgment in the first round. Lord, our SLP was 7172 of 2023 before your lordships.
528, right?
Yes. Now, Lord, kindly turn to Lord paragraph 10.
not clear, who was in Noida. He is an accused. He issued the certificate, one individual. That I give you a certificate of 65B4. He is an accused in 464. That certificate is relied upon by the High Court to throw out everybody that obviously what is recovered from him, that hard test is gospel and all you chaps do not have manipulated over. There are several questions which arise.
In fact, there is no challenge to our appointment. They are participating. Writ petition doesn't contain any prayer to set aside
Correct.
selection. No selected candidate is a party. No selected candidate is a party.
Only waitlisted fellows are
It
here.
is 4.5 years. All those points were raised.
And we are substantive. Our main, fundamental point. How does the High Court terminate? If you are a substantive employee, you have to have an inquiry. That's the basic requirement of 311, that you have to have an inquiry. No inquiry, the High Court terminates because the single judge, who is just now retired, the single judge will not terminate it. The court has no power to terminate. The court can direct an authority. Look at it. So how does the court become an appointing authority to terminate without 35,000 people?
We will show that.
I must say,
These fellows will be out of job. There are 4 people per job who are dependent and 24,000 are knocked down.
I have a moment.
This is something, my lord, which requires your lordship consideration.
May I have a moment, my lord?
but we have all been directed to be taken in custody.
I appear for the commission, my lord.
If there are other petitions,
Yes.
there are.
the numbers to the court master. So if
Yes, we will give the numbers, my lord.
Taken in custody for
No, there's no such election.
But
I appear for the commission, my lord. Give me a minute. I appear for the commission, my lord. We have taken out an appeal. We have, my lord, several issues to raise before your lordship, my lord.
Yes.
We had said that we are in a position to check up who are the tainted persons and who are the untainted persons. Because CBI only identified a few persons as being tainted. On that basis, my lord, the court says incorrectly that it is not possible to segregate. We have made a specific submission that we are prepared to segregate. Your lordship's judgment say that where it is possible.
I find that the CBI report at page 281, that says that they have identified 952 candidates for 9th and 10th.
Exactly.
And about 907 for 11th and 12th.
Yes. So therefore, my lord,
CBI investigation.
that is, my lord, 10%, my lord, of a particular category.
That's 10%, my lord. For 900, you threw out 9,000.
that's a
Your lordships have said, if you can separate the trade.
Hard blood at details, you prove that they're all corrupt.
Monday. Lordship may give us
There are 3 other issues that I wish to highlight.
Your Lordship judgment in 2001 in Delhi, my Lord, Staff Election Commission.
All
94 Krishna Yadav till now. In all such, my Lord, where the records are not available, there is no question of ability to segregate any one of them, and therefore your Lordship decided.
But the evidence has been accepted to OMR.
undertaken, and all appointments have been set aside in all those cases.
It's my lord's own judgment.
High Court is not empowered to do it. That's the High Court, my Lord. Your Lordship in Krishna Yadav said, if the records have disappeared and High Court has raised hand that I can't do anything, your Lordship said High Court should have enabled it and should have passed the order.
Can the High Court not
I need to highlight the huge scam on the minister's others in custody.
One second. Let all other matters which are being filed now or which have already been filed and
Yes.
on board today, they'll be listed together. We'll keep this on next Monday. We'd just like some order so that, if you can just indicate to us what are the categories.
Yes.
Because, there's no point.
What categories?
So if you can just divide the categories, likewise also on your side, so that we have a clear picture of which are those categories in which these different cases fall.
That's right.
But the OMR sheet disappeared, no record.
But only one problem, 36.1 and 36 is not wrongly filed. These 2 SLPs but cannot be kept on record. I need
But Mr.
to that more issue.
Get it this way. OMR sheets are completely missing. The OMR
No,
sheets are
they were-
destroyed.
No.
The OMR sheets are destroyed. They say
Not under the-
even in the mirror server.
Court has accepted, my
We'll have to demonstrate that finding is incorrect.
Not with great respect, under the rules, the OMR of 2016
Jobs are
can't be
put in
retained
the market. What are
The
the
rules provide
How long do the OMR sheets?
1 year, 1 year or 2 years. We are now 8 years down. How can you keep a record? Nobody
That's
can
the
keep
physical
record
copy,
of
not the physical copy.
people not required.
All right. But Mr. Rodgi, consider this. If OMR sheets are now not
This
available
point, yes.
for whatever reason,
Yes.
how do you separate the valid from the invalid?
They went.
Let them produce the OMR sheet before law.
Lord, there are secondary material available.
Oh,
What happened?
Everybody.
This evidence has been gone into by the court and the court says it is admissible.
Yes.
Under 65B. We are not challenging that. But if that is so, my lord, it can be verified. The CBI has used that material.
the SSC has
But
accepted
he
that.
said the certificate issued by an accused.
All you have to demonstrate to the court that it is possible to say in all these matters. But the question is whether you can segregate. I dealt with the Delhi matter, Mr. Dewan.
Yes, correct. We are aware.
We said that it's not possible to segregate in that case. You have Kellon's case. You know, there are cases on both sides.
Correct,
Both
correct.
sides. You have to demonstrate that, well, on the basis of material which is
separable.
available, it is
Yes.
possible to segregate.
Yes,
do that.
So those, because we quite see,
Let them show.
terminate 25,000 people is of a very high order.
Yes, correct.
Unless you are left with a situation where the entirety of the process is wrought with fraud.
But there is no.
To us that, you know, there is material to indicate as to who are the beneficiaries
Yes.
of fraud and those people whose appointments are clearly not.
Para 240, they prepare. So commission gives a table that these are identified, these are not complete, and we can't tell you how many more. That the commission admission.
No,
As they are happily
It is an incorrect statement. We said we can.
We will have to hear the matter. It's not a matter which we can just, you know,
That's right.
T20 matter.
The time takes up plus on Monday, we shall clarify.
8 and 9.
We want some factual clarity.
Yes, sir.
Because when the matter opens, please make sure that, you know, whoever argues in an order. So there should be some element of clarity because the High Court may have had it. They have seen the matter expound before themselves. We don't have it. But we'll look at it threadbare.
Straightly, absolutely, we are grateful.
Direction,
One thing that
direction 8 and 9 should be stayed.
the wrong SLP file, my lord. The writ petitioners was not had there. It is completely different petition. Let them correct it.
All right.
Because direction 8 and 9 should be stayed. Lord,
What is happening between
Let them not.
this is election time and the cabinet.
I'll tell you, Lordship, what will
what
happen
is the
is
date of the judgment?
the 22nd April. Now, my lord, I'll tell you.
We are right in the middle of election.
Officers will be there, some on election duty, otherwise will be picked up right from the bottom till the top. Whoever was involved with the preparation of the cabinet note, whoever the CBI wants today can pick up a custodial interrogation.
Even the cabinet, Lord, the cabinet has passed the order.
Lord, we are on election duty.
Preparing for the,
I am only for 39. I am waiting for your lordships to rise.
oh, you're not in this.
I am
matter.
not in this matter.
But now,
39. I have conveyed to Mr. But I have conveyed to Mr. Bhushan.
So I'm in 38 where
Ek-
the court said give me.
Raju,
Oh, you're not in this matter.
No, it was 11,000 small persons who have been due for. I'm in that matter.
Yes, okay.
my lord,
Now,
I have
once again,
conveyed to
same matter.
Mr. Bhushan, my lord, I have conveyed that the Honorable Court may take a call on my request if he is here, my lord.
We'll allow you to take copies of the report, Mr. Bhushan, and the report of the Secretary of the District Legal Services Committee, District Legal Services Authority, Achar, has been received. The registry shall supply copies to Mr. Prashant Bhushan, learned counsel for the petitioner, and the advocate instructing Mr. Tushar Mehta, learned solicitor general. We'll list it next Monday.